morning, Justices. I appear on behalf of the applicant together with my learned junior, Ms. Lefaladi.
Thank you, Mr. Tsatsawane.
May it please the Court, Justice Mhlanhla and the Justice of the Constitutional Court, Mr. Nguta for the respondent, and I'm assisted by my learned friends, Mr. Zungu, as well as Mr. Sikhachi.
Thank you, Mr. Nguta. You may proceed. Yes. Mr. Tsatsawane.
May it please the Court, Justice Mhlanhla. The appeal before you is one against the whole of the judgment and orders granted by the Supreme Court of Appeal in a matter in which the dispute related to ICASA's powers or lack thereof to condone non-compliance with Section 19, subsection 2 of the Electronic Communications Act. The first issue that we deal with is obviously the jurisdiction of this court to entertain the matter. We submit that the application raises constitutional issues. The application obviously started as a PAJA review in which Open Heaven sought to vindicate its right to just administrative action as protected in Section 33 of the Constitution. It also raises the issue of the exercise of public power by ICASA. And the main issue here being that we submit that ICASA, as an organ of the state, is bound by the rule of law. It can only perform the functions and can only exercise the powers which are vested upon it by the law. And if it purports to exercise powers which are not vested upon it by law, then it infringes the rule of law. And we submit that is a constitutional issue which engages the jurisdiction of this court. Both the High Court and the Supreme Court of Appeal found that there was a power in terms of the ECA, the Electronic Communications Act, in terms of which ICASA was empowered to condone non-compliance with the statutory provision in dispute. And we submit that there isn't such a statutory provision and that this is an issue which falls squarely within the jurisdiction of this court. The next point, we submit that it is in the interest of justice for this court to exercise its jurisdiction to entertain this matter. Firstly, we submit that we have demonstrated prospects of success. We further submit that the matter is of great public importance because it relates to an issue that occurs all the time in the regulation of broadcasting services in the country. But most importantly, we submit that the outcome of this case will provide the requisite regulatory certainty as far as the regulation of community broadcasting radio stations are concerned. In addition, we submit that this issue will arise again because, as we said in our papers, there are pending applications which are awaiting the outcome of this litigation. And lastly, on that point, we submit that this is not an issue which is only peculiar to ICASA's regulatory authorities. There are a lot of other legislation which provide for things to be done within a particular period of time, and the judgment of this court on whether an organ of the state has statutory powers to condone non-compliance with statutory provisions will provide the necessary guidance. Then the proceedings in the High Court. In the High Court, Open Heaven sought to review and set aside the decision of ICASA not to entertain its application to renew its class broadcasting license. That relief is sought in Open Heaven's amended notice of motion, which is on page 011-387 on case lines. And the reason why this is important is not only because that is supposed to be the starting point, but it is also important because the relief which the High Court granted is completely different from the relief which the respondent, Open Heaven, asked for in the High Court. And we will submit that just on that basis alone, the Supreme Court of Appeal ought to have upheld ICASA's appeal. The High Court did not grant the relief that was sought before it because it correctly formed the view that there was no case made for the review relief by Open Heaven. But what it then did was to say it needed to grant what it defined or described as a just and equitable order. And we submit that the legal position on the court's jurisdiction to grant an order which is just and equitable doesn't get invoked until such time that either review relief has been granted or a declaration of invalidity has been granted. We now know that the High Court did not grant the review relief and it did not grant the declaration of invalidity that was sought by Open Heaven. On that basis alone, then the High Court did not have jurisdiction to grant an order which it will have considered to be just and equitable. But in addition to that, the applicant before you, which is ICASA, was in fact not called upon in the notice of motion and the founding papers to deal with that particular issue. And we submit again that on that basis, the Supreme Court of Appeal ought to have upheld ICASA's appeal. Then the matter went to the Supreme Court of Appeal, with leave having been granted by the High Court itself. The Supreme Court of Appeal, we submit, wrongly concluded that in the context of the ICASA Act and the Electronic Communications Act, ICASA has the power to condone non-compliance with statutory provisions. In the manner in which the SCA framed that finding, it then means that one must look at the whole of the ICASA Act and the ECA to find whether or not in the context of those two statutory provisions, there was indeed a separate power hidden somewhere in those two legislations in terms of which ICASA could condone non-compliance with the statutory provisions. And we submit that there isn't such a provision. The powers of ICASA are set out in Section 4 of the ICASA Act, and a simple reading of that section reveals that there is, in fact, no power to condone non-compliance with statutory provision, particularly Section 19(2) of the Electronic Communications Act. Then the Electronic Communications Act itself deals with what is defined in it as individual licenses, and these are ordinarily your commercial broadcasting licenses. And it also then deals with class broadcasting licenses. And those are the licenses that we're dealing with in this application. The ECA deals with the granting of the licenses in Section 5, and then it deals with the renewal of the two licenses in Section 11 and Section 19 of the Electronic Communications Act. Section 11(9) of the ECA, which deals with the renewal of individual licenses, expressly empowers ICASA to condone the late filing of a renewal application. But that relates only to individual licenses. Class licenses with which we are dealing in this application are dealt with in Section 19 of the ECA. And Section 19(2) prescribes the time within which a renewal notice must be delivered to ICASA. It must be delivered 6 months, not later than 6 months before the expiry of the license. But what it doesn't do is to contain a provision such as the one contained in section 11.9 of the same legislation, because it says absolutely nothing about the condonation of the late delivery of a renewal notice. There is clearly a distinction which the legislature has made in section 11.9 of the ECA, because in section 11.9 of the ECA, it expressly empowered to condone the late filing of the notice and to do so on good cause. But in section 19.2, it didn't bring the same provision as far as class licenses are concerned. And that legislative choice, that distinction, is not contested in this application. It was never contested in the High Court, it was not contested in the SCA, and it is not contested here. So that distinction remains as it is, and we submit it is a distinction which must be respected. So if anyone is looking at the context of the ECA and the ICASA Act, the only context that you will find is that there is an empowering provision to condone in section 11.9, and that is in respect of individual licenses, but there isn't the same provision in section 19.2 in respect of class licenses. And we submit that the SCA got it wrong, and we submit that we are entitled to be granted leave to appeal and for the appeal to be upheld. The Supreme Court of Appeal relied on its judgment in Millennium Waste to suggest that an organ of the state is entitled to condone non-compliance with provisions, provided it is in the public interest to do so. But we have indicated in our argument that the Supreme Court of Appeal was wrong in doing that, because the judgment upon which it relied, and in fact that particular part of the judgment in Millennium Waste was correctly overruled in the case of Dr. J.S. Moroka versus Bertram, which is referred to in our argument. The very same court concluded that to the extent that the Millennium Waste judgment concluded that there was a power to condone non-compliance provided it was in the public interest, it was wrong. So insofar as the SCA relied on a wrong part of its own judgment, we submit that its judgment and orders are in fact wrong. We have referred in our argument to some examples where the legislature has decided to empower an organ of the state to condone non-compliance with statutory provisions. The very first example is section 11.9 of the ECA itself. The second example that we've given you is section 80 of the Municipal Property Rights Act of 2004. Section 80 of the Municipal Property Rights Act provides that the MEC for local government may, on good cause and on such conditions as the MEC may impose, condone non-compliance with provision requiring things to be done within a particular period of time. So that clearly indicates that the legislature is fully aware that there may be a need to condone non-compliance with timeframes prescribed in legislation, and where necessary and where a case had been made for it, the legislature made provision for an organ of the state to condone non-compliance with the timeframes prescribed in the Act. In this case, as we said, the legislative choice which the legislature has made here is not to empower ICASA to condone non-compliance. And we submit that on the basis of those examples, it is clear that there is no automatic power to condone non-compliance with statutory provision. A power to do that must be expressly given. We have referred you now as of argument to the case of the Liberal Party versus the Electoral Commission. And again, this is a situation where there was a dispute about the submission of candidates list, which was submitted late. And then the issue arose whether or not the Electoral Commission had the powers to condone non-compliance with the time frame. And this court correctly concluded that the Electoral Commission did not have powers to condone non-compliance with the time frame prescribed in Section 27 of the Electoral Act. So we submit that on those bases, it is clear from these provisions and the case law to which we have referred that there is no power to condone non-compliance with Section 19(2) of the Electronic Communications Act. Then the next point that I must address you on is the question of retrospectivity. Open Heaven, when it instituted its application, it did not institute its application on the basis that its license had automatically been amended or the duration thereof extended by an amendment to the standard terms and conditions regulations, all of which are referred to now as of argument. Because in 2021, the relevant regulations were amended to make provision for that the class licenses will be valid for a period of 7 years. So what it did is it extended the duration of those licenses. And the reason for that is because the Electronic Communications Act itself in Section 19(1) says that the duration of those licenses must not exceed a period of 10 years. In this case, the original regulated provision was that they were valid for a period of 5 years. In 2021, there was an amendment to the regulations to say these licenses are now valid for 7 years. And when Open Heaven instituted its application, it did not rely on retrospectivity. But in addition to that, it did, in fact, try to apply for the renewal of its license. It is only when it became aware of the amendment to the regulations when the record was filed that it then said, voila, there is now a way out of here, which is basically that there was a retrospective extension of that period. We submit that the wording of Regulation 4 of the Standard Terms and Conditions does not allow for retrospectivity. But importantly, Open Heaven doesn't say that this retrospectivity for which it contends applies in such a way that it then gives it a full 7 years period from the effective date of those regulations. It only contends that there was an extension of a period of 2 years. But we submit that if that was the position, the wording of the regulation, which is Regulation 4 of those regulations, would have expressly said so. It will have said all existing licenses or the duration of existing licenses is hereby extended by another period of 2 years. There is no reason why the regulation maker didn't say that if that is what was intended. But importantly, we submit that the wording doesn't support such a provision. So, in conclusion, we submit that the Supreme Court of Appeal ought to have upheld ICASA's appeal, and it then ought to have dismissed the cross-appeal by Open Heaven. We have given you the highlight of our arguments, which are fully set out in our heads of argument. and we submit that we have made out a proper case for leave to appeal to be granted and for the appeal to be upheld, and we will ask for an order in terms of which the application for leave to appeal is upheld, and that the order of the SCA is set aside and replaced with an order in terms of which the appeal is upheld with costs and the cross appeal is dismissed with cost of true counsel. Those are our submissions.
Thank you, Mr. Tsatsawane.
As a pleasure, court.
Just to start off, I know that you are not here representing the Parliament, but I just want to have an understanding. Maybe you can help us as a regulator. Why there was an express provision under the individual licenses for condonation, and there is nothing when it comes to the class licenses. Perhaps if you could maybe provide, just tell us more about these two types of licenses.
Yes.
The distinction, if there's any distinction between them.
Yes. The individual licenses are your normal commercial broadcasting licenses, and the class licenses are your community radio stations. I don't exactly know the real reason, but from my experience, it does appear that the legislature must have been concerned about the manner in which community radio stations are regulated. And this is a classical example, Open Heaven, it's a classical example of it. If you'll see in the papers that from the time that the license had been granted, the people that were originally controlling the license and the radio station were somehow divested from it. Open Heaven itself says the radio station was captured from Hammanskraal, and it was operating from somewhere in Pretoria West. And those are the governance issues that we will submit may have influenced the legislature not to make those provisions.
For the commercial licenses, or I suppose that would be companies, they are then allowed, if one is late, they can apply for condonation.
Correct, yeah. So if a commercial radio station is late with its application for renewal, it is permitted in terms of Section 11.9 to apply for condonation for the submission of a renewal license, yes.
And community licenses, that provision is not there. But the provision that is there, for whose benefit is it? The 19, is it 19.2?
19.2, yes.
Yes.
Yes, that is we submit that is in the public interest for a variety of reasons. Because if a community radio station, for example, but the same applies to commercial radio stations as well, because what they get granted when they get two licenses. They get what is called a spectrum license. That is now licensed to allow them to operate in the airwaves, and then a normal broadcasting license. For example, if you don't tell ICASA that you want to continue providing the service, ICASA may decide to allocate that particular spectrum to somewhere else, or it may advise the minister that this radio station and that radio station have not given me notice that they want to continue. You may need to issue an invitation to the public to apply for that particular spectrum. That may be the reason, yes.
Is that,
Yes.
is it possibly another reason, would it not also to also assist ICASA to regularize its affairs as and when applications come in?
Yes. For example, if let's say a commercial radio station does not apply, the same reason that I've given would apply, and the reason that you have given would apply, because it usually for commercial, for class licenses, there's usually an invitation to apply for the license. And you may find that there's 20 or 40 applications that are granted at the same time. And by the time that these licenses expire, they may be expiring at the same time, and ICASA may need to be given sufficient time to know who is still in the running and who is not in the running for it to know how to manage the spectrum.
Mr. Sassola,
Yes.
can we start at the High Court's order
Yes.
and its reasons?
Yes.
And before we get there, can we look at the judgment in paragraph 37, 38, 39, and 40?
Yes.
My understanding of the judgment is that in summarizing the applicant's submissions, the High Court in paragraph 38 says the applicant agrees that section 19 does not confer a discretion on ICASA to accept a renewal. And in the result, it says in the same paragraph, ICASA is not empowered by the Act to consider the request for condonation. You would not have a problem with that.
Yes.
However, in the next paragraph, it says, it talks about a discretion. This is where you have a problem with, to say, section 19.2 grants the court their discretion, whether express or implied, to condone. That's what it says.
Yes.
And that seems to me to be the basis upon which the High Court came to the conclusion that ICASA, because ICASA has a discretion, that discretion grants it the powers to condone, right?
Yes.
And in paragraph 49, the High Court says, I am satisfied that ICASA may, in its discretion, waive the 6-month time period. Right?
Yes.
You have contrasted the two provisions which you have now discussed with the ADCJ, section 11.9 and the 19.2.
Yes.
You say the express intention of the legislature should be found or can be found in 11.9. Insofar as the impugned provisions, there is no express provision. In other words, for condonation to happen or to occur, we need to source the power in section 19.2.
Correct.
And you say section 19.2 does not afford does not grant that power.
Correct.
The SCA in its judgment in paragraph 19 made reference to also what you have discussed with my learned sister presiding, that the purpose of the provisions was or is for the benefit of ICASA. And it tagged along on the issue of this discretion. Let me try and understand this argument of the applicants. If a licensee in the position of the applicant with a license with its duration for 5 years,
Yes.
come 5 years on ICASA's construction, after 5 years, it's carried twice too, if
Yes.
you have not applied within the 6 months period.
Yes.
But the applicants are saying the regulations that were amended or promulgated in March sought to introduce a further period of 2 years.
Yes.
Is it logically proper to say that 2-year period should be reckoned from the date when the license was given? In other words, on the effective date. And if it is so, then would it then be correct to say licensees in the position of Open Heaven interpreting the regulations, they need not apply for any extension? Would that be the proper legal position?
Well, in the context of this case, we obviously dispute that that interpretation. If the provision has a retrospective effect, then they will not have had to apply, because they will have had an automatic extension by a period of 2 years. But we submit that the wording simply just doesn't permit retrospectivity.
Can I ask you to look at, just solicit your view.
Yes.
We have the Act in Section 19.1, and we have the regulations.
Yes.
Vis-a-vis one another or each other, which ones should prevail? Is that the regulations or the amendment or the Act?
The legislation, obviously. The legislation. The regulation is subordinate to the legislation.
So is that your understanding, that the regulations as is means that the 7-year period would start to kick in when, and what would be the effective date for the 7-year period to be counted? To be
Yes.
counted back, because somewhere it says past, present, or future.
Yes. Yeah.
And
so,
which past would that be?
Yes. So again, Open Heaven is a classical example of that, because the effective date that is referred to in the amended regulation, that is the effective date of the amendment itself, which is 21 March 2021. But then you also have an effective date in the license itself. And the license may be issued, let's say, on Friday, and it may be signed on Friday. And the ICASA may say your effective date for this license is going to be next week, Monday. Or it may say, depending on the circumstances, that even though I'm issuing you the license today on Friday, your effective date is yesterday, which is the past. And depending on the circumstances, it may very well be that the broadcaster may have been broadcasting under some arrangement between the parties, but the license is then issued a day or 2 days after they started broadcasting, which may be permitted, in which event then the effective date is clearly a date past, and if the effective date is on Monday, it is then going to be a date in the future, and if it is from the effective date on which the date is, the license is issued, will then be the Friday, using my example.
So the sum total of your argument is that the regulations do not come to the assistance of Open Haven.
No, we submit not, they don't.
I looked at the judgment of the SCA.
Yes.
And I'll just say what it says. And it talks about, there are various aspects of the judgment that were left hanging and unexplained. One other is the substantial compliance.
Yes.
Where does one find that in the sections?
Well,
And also in Open Haven's case that it has substantially complied with it.
well, in the context of this case, you don't find that, because here we're dealing with a time period. Either the application is in at 1 o'clock or it isn't. And if it is not, then there's no compliance substantially or otherwise. And that will usually, a substantial compliance will be in a situation where, say for example, the application is submitted on time, and maybe 1 or 2 issues have not been properly dealt with, and which ICASA can find in the application and remedy it. Then one can talk about substantial compliance in that kind of a context, but not in this context, because here an application is either in at 10 o'clock or it isn't, and if it is not, then that is the end of the game. That, I think, we have dealt with it in our heads of argument.
Will your argument be different if ICASA, if Open Haven was within time to file the application, a renewal, through no fault of their own, on the examples that have been postulated, something happens at your offices and at ICASA's offices, and they can't accept the application. So would then, in those circumstances, you say to them, end of the story, cut-off period, shut down?
Well, that is where, I mean, if it was as a result of something at ICASA's office,
yes,
then the position will be different.
Why? And where would the question would be, now you say there has to be, ICASA must source the power elsewhere. And where is the power going to be sourced by ICASA to condone its own actions?
Oh, yes, so I thought you were still on the substantial compliance issue.
I'm done there.
Ah, okay, yes. So if something were to happen at ICASA, but the application had been submitted.
No, they are going to ICASA to submit the application.
Yes.
Lo and behold, the example that has been put is that there is fire at ICASA.
Yes.
They are at the gate, there's nothing, and the security guy or security personnel cannot accept the application. What happens in those circumstances?
Well, something like that happened. It's said in the papers where there was a fire at ICASA, and at some point ICASA didn't know who had submitted and who had not submitted because of the fire. And then ICASA issued a notice to say everybody who had not yet submitted an application, a renewal notice, must now do so within a period of 30 days. That is what ICASA did at the time. Whether that was right or wrong.
But doing that,
yes.
what is that conduct in terms of the provision of Section 19.2?
Well, I can tell you that ICASA thought it was doing right at the time, but it did not have a power to do that.
So in your argument today,
yes,
what ICASA ought to have done was to say, we had a problem, it's none of your business, you were here on time, you could not shut down. Just think about it.
yes.
And people would walk away and shut down the committee stations.
Well, it will not mean that they will not have had remedies.
Yeah, but we are debating the Section 19.2.
Yes.
Where you said it allows no opportunity at all. Once you don't come within the 4 corners, there is no implied power, there is no condonation, there is no discretion. It's
yes.
open and shut.
Yes. So in that kind of a context, there will be nothing preventing ICASA, for example, to approach a court to say, I had a fire in my building. People could not submit their applications. And their applications were submitted and were rejected because they were submitted late. ICASA could have approached the court to review its decision not to accept the applications and ask for a just and equitable remedy that would then have allowed it to entertain those applications. That remedy will always have been there for it.
But why is the same not applicable here?
Well, that is not applicable here because no one has invoked that remedy. Open Heaven has not invoked that remedy. It tried to do that in the High Court, and the High Court rejected it.
But when you go to the High Court, you
Yes.
would ask the High Court to look at the provisions of Section 19.2. You would say to the High Court, the provisions of Section 19.2 do not allow us.
Correct.
And then you would say, you could imply in the one in 19.2 that we have the necessary powers to condone, even if you may not use the word condone, to
Yes.
accept the application. To say, you would have to say something. Play the
Yes.
devil's advocate. Let's
Yes.
see.
Yes. Well, if that were to happen, obviously it will create a difficult situation which will have to be addressed. But in the context of this case, unfortunately, that is not what happened.
I'm trying to test the provisions of 19.2 to
Yes.
say it's hard and fast, or it allows for the exigencies that Open Heaven has utilized. So the other side of the coin.
Yes.
And if you say it's not,
Yeah. So with that, if one were to go and argue for an implied power, it obviously then goes into a whole different territory. There's a judgment of this court in Amabungane where the issue in dispute was about the power to appoint a judge to authorize interception of communications. And the Act made no provision whatsoever for the minister to appoint that particular judge. And this court found that if you don't imply a power for the minister to appoint that judge to authorize interceptions, the whole of the Act will collapse. And it is for that reason that the court said, in that kind of a context, unless you imply, the purpose of the Act will be frustrated. This is not such a case. This case, this Act continues to operate, and community radio stations continue to operate. They submit applications on time and so on. Yes,
thank you, Mr. Sazama.
thank you.
Thank you, Mr. Tsatsatwane. I'm just concerned about the question that the acting Deputy Chief Justice asked you and your response to it, which relates to the purpose of the statute and why it would be that individual license holders should be afforded the right to apply for condonation and why the other could not be implied in respect of communal license holders. I mean, essentially, in response to Justice Matopo's questions, you're suggesting that where condonation is sought by a community radio station, they would have to really approach the court for that condonation, whereas individual license holders, such as the big players, don't have to do so, because that's what the Act says. Now, can the Act really not be read to imply such a power in Section 19 to communal license holders?
No, we submit not, because if you're going to exercise your reading in power, you first have to find that the section is unconstitutional. Then you can read in some words into it.
Well, what about judgments such as Baxter in the Western Cape High Court, which was supported in Park Avenue by the SCA? What about those judgments which say you can read into a statute?
Yes, but in this case, the High Court was not asked to do it. The SCA was not asked to do it, and This
Well,
court is
it's not a
also
formal
being asked
reading,
to-
and that you can imply it from the terms of the statute. That's what Baxter said.
Yes.
You can imply that the power to condone exists when you grant an organ of state or somebody else, a body such as ICASA, a power to grant a license. You can imply then a power to condone where there, for instance, was a fire at the gate.
Yes, but in the context of this case, you have a clear indication from the statute itself that the legislature deliberately decided to treat the two licenses differently.
But what would the purpose for that be? I mean, that's what I don't understand.
Yes.
Why would you place such an onerous burden on community radio stations? What would the purpose of the statute be in doing so?
Well, the difficulty with that is I can only give you a guess, but, and that is because that was not an issue which we had to address. And I think the best person to answer that question is probably the minister responsible for that legislation. But we can only speculate that it is pretty much because of the governance of the two types of radio stations.
But because that argument is so weak, with respect,
Yes.
it suggests that you could imply the power.
Well, we submit that on the authority of the Amabungane case in this court, only if the purpose of the legislation as a whole is going to be negatively affected without that power being implied. But this is not such a case here. This is a case where you have got few community radio stations who do not comply with the time frame prescribed in Section 19.2. And the whole scheme of the Act continues to function because these are just few of the community radio stations that are affected by this.
My other question relates to the issue of the regulations. If the court were to find against ICASA on retrospectivity, is it necessary to reach the condonation issue? On the one hand. On the other hand, if the 7 years applied, would the retrospectivity argument not be moot, given that the license would have expired in 2024?
Correct, yes. That's how we say it, yes.
All right. Thank you.
Mr. Tsani, this court has expressed its view and developed the jurisprudence on the whole question of implied powers.
Yes.
And in brief, it would suggest that implied powers would have to be necessary
Yes.
in order to exercise the principal power, and that if one did not imply the existence of such a power, it would make it difficult for the principal power to be exercised. Does that doctrine have any application here in the context of an application for condonation, which is not granted expressly to ICASA to consider in respect of these classes of license, but that in some of the examples offered by my colleagues, it would render the exercise of the express power very difficult, if not impossible, if one didn't imply the ancillary power to condone a late application? Is there any merit in that submission?
Well, in general terms, yes. But in the context of this case, we will submit not, because these are isolated incidents. These are not incidents that are applying and prevailing across the board. These are few community radio stations which failed to comply with the time frame for one reason or the other.
Sure, but I'm not referring to these community radio. I'm asking as a general principle.
Yes, as a general principle, yes, it will be the position, yes.
What would be the position?
If the power cannot be exercised at all, then it may be necessary to imply that the ancillary power exists. And that is the example that I've given in the Amabungane case. Because in Amabungane, if the minister didn't have the powers to appoint a judge to authorize interceptions, then the whole act will not operate. and then the powers granted to a judge and everybody else to do interceptions will not be exercisable.
But in these instances, if it was objectively impossible for an applicant to submit its application timeously, and the express power to consider a renewal could not be exercised by ICASA because of those objective circumstances, then under those circumstances, could one not strongly argue that one must have the implied power to condone the late submission? All that would mean is that then one tailors the circumstances under which it is necessary
Correct.
to exercise the implied power, but that would not stand in the way of a court interpreting the section as to give an implied power, albeit under limited circumstances. What would you say to that?
Well, I think it's an issue that we have addressed, and that is why we have given you some of the examples in other statutory provisions. Because in the context of this case, if you were to imply that power, what will you then will be the circumstances under which that power could be exercised? Because the legislation is silent. In the legislation that we have referred you to, starting with the ECA itself, it must be on good cause. The Municipal Property Rights Act itself is on good cause shown. If you were to look at other provisions, statutes authorizing a court to condone, for example, Section 9 of PAJA, it says you can condone the late, extend the time frame if it is in the interest of justice. So here, it's not only just going to be a question of implying the power, but you'll have to define the circumstances under which the power could be exercised. But that will be now going more than implying the power.
Okay. And would you say that that would infamously breach the principle of separation if the court would then have to develop those principles?
Correct.
To what extent, finally, is the deliberate distinction that you say the legislature made in dealing with individual license and these categories of license suggestive that it was part of the clear legislative intent to distinguish with how late applications are to be dealt with? And once that is quite clear, then the court must give effect to the clear language of the section.
That's our submission, yes.
Okay, thank you.
Mr. Twatswane,
Yes.
even if this matter does engage this court's jurisdiction, is it in the interests of justice that leave to appeal should be granted?
Yes.
Let me put it differently. What would be the practical effect of between the parties of an order in this matter in favor of the applicant?
Well, we have outlined a long list of bases on which we submit it will be in the interest of justice. For example, from paragraph 2.16 of our heads of argument, I think all the debate that we are having now it does indicate that there is a need for this court to express its view on these issues. The matter is not only limited to Open Heaven. It applies to other community radio stations as well who have applied late, and our applications
For now,
append.
can you please just confine yourself to my question, please?
Yes. Yes, in the context of between ICASA and Open Heaven, then there may not be any effect of it. Because on their version, even if the extension has a retrospective, even if there is a retrospective effect, then that time will have passed.
You concede there might not be any effect on the parties per se.
Correct.
So is ICASA then just coming to this court for direction and for advice?
No. We're not coming here just for advice. The matter does raise a matter of public importance, and we say that in our heads of argument, not only for this case, but for other cases as well in the future to come. There are pending applications that ICASA must entertain, which are waiting the outcome of this case.
And this court's judgment would give direction on how ICASA will deal with other matters.
Yes, correct.
So you are in effect approaching the court for advice and for direction. Is that the court's role?
Well, that is not the only basis on which we rely for our submission that it is in the interest of justice for the court to exercise its jurisdiction on this issue. We have dealt with them in paragraph 216 of our heads of argument. And I think the one that you have raised, I think, is just one of them. So from what you are raising, it may not be the best of the points, but there are other points that we have raised.
What's the applicant's strongest points for the interest of justice case?
Well, the first point that we have addressed is that we do have...
The applicant's strongest case.
Yes.
For the interest of justice argument.
We have reasonable prospects of success on the grounds on which we rely. And the matter is also of great public importance, not only in respect of this legislation, but in respect of other legislation as well, where time bar provisions are provided for.
In respect of retrospectivity,
Yes.
does the presumption against the retrospective operation of law apply where no vested rights are taken away and only benefits are conferred?
Well, it will apply if vested rights are to be taken away, but in this case not.
That's my question.
Yes.
Does the presumption against retrospective operation of the law apply where no vested rights are taken away and only benefits conferred?
I'm not sure I'm understanding the question. If I understand your question, you're asking if the presumption against retrospectivity still applies where no vested rights are taken away. Is that the question? Yes, we submit it will apply, yes.
It will still apply?
Yes.
Why?
Because, and again, you'll pardon me for this, because we can only limit it to this case, because this is not only peculiar to this application, it is peculiar to all type of applicants who are affected by this. And in this case, they don't have an automatic right to broadcast. That right is limited by having a license. And in this case, when the license expires, that right expires as well.
And is it correct that they are still broadcasting?
I don't know if they're still broadcasting.
Doesn't the paper say that they are still broadcasting?
Well, but we don't know. I don't think anyone has done an assessment of whether or not it is correct that they're broadcasting.
Yes. Now, some of my colleagues have asked you about this, and it's an important question. The legislature deliberately distinguishes between class licenses and individual licenses.
Correct.
What purpose does this differentiation serve? Or in other words, is the differentiation rational?
Well, it's a difficult question for ICASA to answer that question, and it is because of two reasons. Firstly, that was not an issue in both the High Court and the SCA. And secondly, the distinction was made by the legislature, and that's why I said perhaps the minister may be in a better position to answer that question, but that's not the issue that is now before this court. It may very well be that the distinction should not have been made in the first place.
What purpose do you say is served by the 6-month time bar for class licenses in Section 19(2) of the Electronic Communications Act? And why did the legislature not include such a limitation for individual licenses?
Well, the The time period for in individual licenses is dealt with in the regulations, and I think we have dealt with it in our as of argument. But the main purpose that comes into play relates to the allocation of radio frequency spectra, because if it is not available, ICASA may allocate it to other operators. It may not necessarily be community radio stations, but there may be other players in the industry who may require and use that radio frequency spectra.
If that ICASA's view is that it did not have the power to condone non-compliance with Section 19.2. If for a moment we put the competence to condone aside, was the non-compliance material?
In the context of this case, yes, because on Open Heaven's own papers, the non-compliance was as a result of, one, the radio station had been captured by others, and secondly, they didn't have a properly functioning board of directors managing the radio station. So it was a material non-compliance.
Submissions that ICASA makes, it says that the Supreme Court of Appeal erred in its reliance on all play.
Yes.
Do you maintain that?
Yes, we maintain that.
In all pay, did the court not merely lay down a general principle, and a principle that has been affirmed in other judgments, that when assessing compliance, a court must look at the purpose for which the requirement existed was fulfilled?
Yes. But I think one has got to look at I think it is in paragraph 19 of the SCA judgment, where a reference is made to all pay. The court was dealing with non-compliance with, not non-compliance with statutory provisions. It was dealing with non-compliance with tender requirements. And in the context of the ACDP judgment relied upon in that case, the court quoted Justice O'Regan as having that the determinative issue is still whether what the applicant did constituted compliance with statutory provisions viewed in the light of their purpose. And again, the purpose here, we will submit that it enables ICASA to manage the spectrum and to deal with allocations if and when required. And that purpose cannot be served if ICASA is in the dark as to who is still in the running for the next 6 months and who is no longer in the running for the next 6 months.
What do you mean when you say who's in the running or who's not in the running?
I mean, who still intends to provide broadcasting services, because the section says if you still want to continue to render broadcasting services, you must give notice that you intend to do so.
Now, let's look briefly at Pepper Bay. What policy considerations do you say underlie the presumption against implied condonation powers as was found in Pepper Bay?
I think in those cases, if I can just I think in all those cases, the courts will have been concerned about the achieving the purpose which was intended to be achieved by the relevant provisions.
And how would that principle influence this court in deciding this matter?
Well, in this case, you have a regulator who must be given notice that radio frequency spectrum is still going to be required. And who can make a decision on making the spectrum available to other users who may need it? And that is the purpose which we submit, is of paramount importance here.
Now, my last question. In paragraph 6.11 of the written submissions on behalf of the applicant, it is stated that the Supreme Court of Appeal failed to distinguish between a power and a discretion. Now, can you explain how this failure and to make this distinction assists the applicant?
Yes, so in the context in which we said that, we will submit that the SCA concluded that there was a discretion to condone. But what we submit is you must first have a power to condone, and then the discretion allows you to choose left or right, whether or not to give the condonation or not. That's the context in which we said that.
Thank you very much, Mr. Tswatatswane.
Mr. Tsatsawane, can we talk briefly about the amended regulations, the 2021 regulations?
Yes.
I heard you say that the effective date referred to in the regulations, amended regulations that is,
Yes.
refers to the effective date of the amendment, that is March 2021.
Correct.
Where do we find that?
Can just take you to the regulation. I think that is in the regulations. I'll take you to it now.
Let me tell you why I asked that question, so
Yes.
that you can perhaps just answer everything at once.
Yes.
The respondents point to points to Regulation 4, which reads, the following licenses are valid for 7 years from the effective date.
Yes.
And then the licenses are listed.
Yes.
They then refer to Regulation 2.2 that defines the effective date, and it defines the effective date to mean the date specified in the license, which may be a past, present, or future from the date of the signature.
Correct.
So what the respondent says is that the regulations are at least capable of being read to mean that the 7-year period must be reckoned from the date you look at the date on the license, because
Yes.
that's what Regulation 2.2 says.
Yes.
What's your difficulty?
So,
with that?
so if you're looking at the
But first, before you answer that question,
Yes.
you must first show me where we find this reference to March 2021 being the effective date, and then we will then interrogate it with these two provisions.
Yes, the regulations themselves, in paragraph 13, it says that they will come into operation by publication in the Government Gazette, which was, 25 March 2021.
Sorry, where is that? Someone was trying to direct, I accepted, but it just took me to the first page of the regulations.
Oh, I think my junior was doing that. That will be page 011-258. 011-258. That is the date on which the regulation, the amended regulation came into operation.
That is the date when the regulation, we accept that.
Yes.
They have to have a date when they come into
Into effect, correct, yes.
But the question is different. The regulations seem to say that if you must look for it says, in respect of those licenses, the 7-year period must be reckoned from the effective date, and the effective date is the one that you'll find in those licenses.
Correct.
Yes.
Yes, that is on page 011-252. That is the one which defines effective date to mean the date specified in the license, which may be past, present, or future date from the date of signature. And the date of signature there is the date on which the license is signed.
So the respondent says the license they have has an effective date which is September, I can't remember the year.
Yes.
So the effective date must be reckoned from that date which appears in that license.
Yes. That we accept. The effective date of the license is the 2017 September date.
So they say the effect of the amendment
Yes.
is that their license then became valid for 7 years, effective from the date that appears, in fact, effective from the date that is set out as the effective date in the license itself.
Yes.
It is at least capable of that rating, isn't it?
No, we submit not. If let me just take you to the license itself, which is FA1 on page 011-43.
No, but I don't think that is.
Sorry, Mr. Tsatsawane.
Yes.
Could you also, when you refer to the record, also refer to the hard copy?
Oh, yes. It will be page 30. That's the hard copy.
Sorry to interrupt
So-
you, Mr. Tsatsawane.
Yes.
We must
So-
read the regulations
Yes.
to make a conclusion whether it affects the existing licenses. So I
Yes.
don't think that looking at the license itself will be helpful. These two provisions that I referred you to are contained in the regulations themselves.
Yes.
So you say that they are not capable of being read to mean that the existing licenses are extended for a period of 7 years, effective from the date of those licenses. Just explain that to me, why you say that.
Yes. So the
Linguistically, at least,
Yes.
isn't that a plausible way of reading them?
just so the regulation, as you correctly pointed out, it defines effective date, and it defines it with reference to the signature date and with reference to a date which is before the signature date or a date after the signature date. And we...
No, it defines it with reference to the effective date in the license. That's what it says.
Correct, yes,
Yeah.
that is what we are saying. And the license in this case is the clearest example of what that definition is talking about. So the date of signature of the license is 26 May 2027. So 26 May 2027, the license is signed, and that is on page 29, 011-42. But then the license period itself is not 26 May 2017. The effective date, which you will find on page 30, 011-43, is 12 September 2017, a few months down the line. So that is now a date in the future of the signature date of 26 May. And then the license shall expire on 11 September 2022. What the respondent wants you to now do is to read paragraph 2.2 to then mean a date in September 2024. That is the argument. And we submit that the wording of the amended regulation 4 does not permit that. And there's a long list of reasons why you will not read it like that, because every renewal, every extension of a license must go through a certain prescribed procedure. There are certain requirements that
But
must
you're
be...
going outside the reading of the regulation now, isn't it?
No, but you've got to
Because-
you've got to read it in the whole context of it.
Yes.
Yes, and the context of a renewal, it goes through a process. There must be a
No,
feasibility
sorry,
study.
let me just interrupt you.
Yes.
What we are interrogating is this. Did the regulation have the effect in respect of all the licenses, the existing and the future? That's the debate. The respondent says it cuts across. It cuts across because it says that this 7-year period must be reckoned from the effective date that appears in the license.
Yes.
So where do we find this differentiation between the existing and the license still to be issued? That's really the nub of the debate.
No. We're not making a reference to licenses which are still to be issued. We are saying that amendment applies to licenses such as the one that they have, and when they apply for a renewal of the license, because ordinarily before the amendment, your renewal will only be 5 years. But when you apply for a renewal, then you'll get 7 years.
We
That
are
is-
probably talking past each other. Let's take it slowly.
Yes,
Obviously, the licenses that would be issued after the promulgation of these regulations would be effective for 7 years, right?
correct.
And what is the position in respect of licenses that had been issued when the regulation was promulgated? That's the question, really.
Yes. So,
Does it affect them, their validity period?
so it affects them in the following manner. If your license is expiring on year number 5, then that's the end of that license.
Where
But
do we
if-
find that?
Well, you will find that in the license period itself.
No, we're talking about the regulation. I'm talking about the effect of the regulations, of the amended regulations on existing licenses.
Yes, I'm coming to that.
Yes.
Yes. So if your license is 5 years, like Open Heaven's license was 5 years. So if they had applied for a renewal on time, they will then have benefited for a full 7-year renewal period in terms of the amendment of the regulations.
I
But-
don't quite follow that. Just explain it.
Okay. So Open Heaven's license was issued on 26 May 2017. The effective date of it was 12 September 2017. The expiry date was 11 September 2022.
Yes.
That's the 5-year period. In 2021, the regulations are amended to now make provision for this type of licenses to exist for a period of 7 years. So if Open Heaven did not want to broadcast and did not apply for renewal, its license will have expired on 11 September 2022. But if it applied for renewal...
Sorry, so the short answer is that the amendment does not, your answer is that the amendment does not apply to existing license. That's the short, that's the sense I'm getting from you. The amended regulations they don't affect existing licenses. That's the answer really, isn't it?
No, with respect, no. It affects them when they are renewed. When you renew it,
So
you get
when
7
do we
years.
find that it only affects them when they are renewed? Where do we get to that now? In the
That-
language of the regulation.
Well, that is the submission that it doesn't have retrospective effect. That's the submission we make, because the
But
submission made...
you are reading into that regulation that it will only affect them in relation to a renewal, and I don't see that in the language, at least of the regulation. That's my difficulty.
Yes, so if you read the regulation, and I think this is the nub of the argument. If you read the regulation to have retrospective effect, yes, this license has been renewed for another 2 years. That's the effect of the retrospectivity. But we say that amendment does not have retrospective effect because the wording of it doesn't support retrospective.
Which wording does not support that interpretation?
The amended regulation 4.
But that regulation is the one that just lists licenses that that are valid for 7 years, without differentiation. That was really what I wanted to get from you, because you, in your submissions earlier on, when you in your interrupted time, you shortchanged it and you said no, the language, the wording does not support the retrospectivity. So I'm just trying to understand that.
Yes.
Why do you say which wording do you say is not capable of supporting the retrospectivity?
Well, the submission is this, that when legislation and regulations are promulgated, unless the wording of it expressly says that it shall affect existing positions, the presumption is that it applies prospectively and not retrospectively. That is the argument.
All right, thank you.
Yes.
Thank you, Mr. Tsatsawan. If I understand your case really, firstly, there are two pillars to it. Pillar one is that the SCA got it wrong because it read the regulations to have a retrospective effect, and that's in conflict with the presumption. That's a fair summary.
Yes.
And pillar two is that the SCA got it wrong because it held that the ICASA has the power to condone, but when you read the act, the power doesn't exist.
Correct.
And you support that with a comparable provision in respect of individual licenses. You say if the legislature wanted to give the power to class licenses, it would have done that. That's really what you have come to say to the court.
Yes.
Yes. Now, on question 2, Justice Savage and Justice Teron have debated with you the question of mootness, that the issue, in fact, may be moot because whether you are wrong or right, the case of the respondents is that they got an extra 2 years, but that extra 2 years has come and gone.
Yes.
So as we said today, the case is moot. What is your answer to that point?
Well, our answer to that is that it is still in the interest of justice for this court to answer the question whether or not ICASA has this power or not.
Which power? I'm not talking about...
The power to condone.
No. I'm not talking about the condonation. I'm talking about the question whether Regulation 4 applies to existing licenses or to licenses to be issued in the future. That issue is moot.
Oh, yes. Oh, sorry. Yes. I misunderstood. Yeah, that point is moot because the time period has passed. Yes.
Exactly. And there is no interest of justice issue that arises there.
In relation to that point,
yes.
No.
Yeah. So, all right. So we can scratch that.
Yes.
Now, we then deal with Pillar 2, which is the condonation power. Now, as I understand the judgment of the SCA, the order does not say anything about the power of condonation. The debate is only in the judgment itself.
Correct.
Now, given that we are dealing with an application for leave to appeal, in addition to the points that Justice Teron debated with you, why would it be in the interest of justice for this court to entertain an issue over which there is no order, given the principle that an appeal only lies against an order, not against reasons?
Yes, that is quite correct. The difficulty with that is because it's an order of the
Of
SCA,
remitter.
that, yes, this, yeah,
Yes,
correct.
but that's an
There's the
irrelevant
remitter.
order because it's not followed by a declaration of any power and it's not followed by a review. So it just
Yes.
exists in the abstract.
Yes, so that is that was exactly the complaint before the
Yes,
SCA, because
yes.
that is
No, I
exactly what
understand
the High
that,
Court did.
but it's
Correct.
irrelevant
Yes.
to the debate here because there is no order declaring that ICASA has the power to condone. And there is no order setting aside ICASA's refusal to condone. So in effect, we are dealing with a debate about reasons, which is probably why I'm not making a judgment, but I'm saying it's probably why Justice Teron is probably right when she says to you, you've really come for advice.
That is if you only look at that point as if that is the only issue that we rely upon for the interest of justice, because
Yes, and I understand there are other points, but I don't want us to leave this point
Yes.
sort of in the air.
yes,
The point is simply this. There is no order declaring ICASA to have the power. There is a debate in the judgment. That is all interesting, but legally inconsequential. And so why should we use the discretion of this court to give you leave to appeal on a matter where there is in fact no possibility of entering the debate?
well, you will have seen in the papers
Yes.
that Open Heaven still wants its renewal application to be considered by CASA. So if that paragraph, Roman figure 3 of,
But I will not back Mr. Tsatsawan to the problem that what you want is an advice about what to do with a future application for condonation.
no, even this application, because Open Heaven still considers itself to be entitled to have its application considered by CASA in terms of this order.
Well, the current license can never be considered because they did get the 7 years. And the only issue is that they must apply for renewal within a period of 6 months.
Yes, they must apply for renewal, and they have submitted a conditional application.
Well, then ICASA must consider that.
Correct, yes.
So
And,
what's the problem?
and that application can only be considered by CASA if ICASA has the power to condone non-compliance with 19.2.
No, but that issue became moot as soon as the SCA said that the actual period is not 5 years but 7 years, because they didn't then therefore have to apply for condonation. They simply had to apply for a renewal within 6 months before the lapse of the 7 years, so which they have done as a conditional application. But then ICASA must look at it in substance. Is it a good application or a bad application? Then the whole issue of condonation really becomes irrelevant.
No, the issue of a condonation is not completely going to be irrelevant, because
How is it going to arise in this dispute?
that application was submitted late.
You mean the extension
Yes.
of the 7 years?
Yes.
But that issue is before us, or it will be if you go to the High Court, and I don't understand.
No, so if you find, if this court were to find that and let me just put this in the correct perspectives.
Yes.
So if this court finds that, for example, a Roman figure 3 is out because there was no declaration of invalidity or review relief,
Yes.
then Open Heaven can't rely on that order. But then Open Heaven will now rely on the conditional application, which is part of these papers. In fact, we are criticized for not having agreed to entertain that application. So if that application is to be
Sorry, Mr.
considered...
Tsatsawan, I don't want to interrupt you. I know what it means to be interrupted by a judge.
Yes.
So forgive me, but
You
I
are
am trying to get clarity.
Yes.
Yes. He's now disappeared. Okay.
Yes, sorry,
Yeah,
sorry. There was something distracting me.
No, that's fine, no problem.
Yes.
So there was the first application, right, which caused the current dispute.
Yes.
Yes. And then there was a 7-year period that was given by the SCA. So which meant that Open Heaven did not need to apply for the previous condonation. They simply had to apply within 6 months after the lapse of the 7 years, no longer 6 months before the lapse of the 5 years. Now, which application are you referring to when you say there is an existing application to be considered by ICASA?
There is a conditional application based on the retrospectivity argument that says
In other words, if you win here,
correct.
then
So it is, sorry if I can finish this. So it goes along the lines, if we win on the retrospective argument.
if ICASA wins.
No, if they win,
Yes.
if Open Heaven wins on the retrospective argument, and there is no application for renewal, because then that retrospective period will have lapsed in September 2024.
Yes.
And that's why they then brought a conditional application.
No, but I'm saying that would have been brought timeously. There is no condonation issue there. Then your client must just consider it on the merits. And then again, I don't see how you enter the debate about condonation other than an abstract conversation about the future conduct of ICASA.
Yes, and we have said that in our papers. And this court may agree or disagree with us.
Yes. All right.
Because
So-
one
so
way or the other.
Would you say, therefore, it's really about the interest of justice that you say, okay, well, this may not be technically within scope, but it's overall in the interest of justice that you tell us if we have the power or not?
This is what we say in paragraph 2.16 of our as of argument, because as we have said, there are pending applications that are waiting the outcome of these applications, and which were submitted late.
And it happens regularly that people are late.
Yes, it happens regularly that people are late, and ICASA takes the view that I don't have the power to condone.
Yes.
So if you don't resolve that issue in this application,
Yes. We leave you and the community in limbo.
correct.
Yes.
And that is why we say it is in the interest of justice for this court to entertain this thing and express a view on it.
Yes, all right. No, I understand. Thank you, Mr. Tsaswa.
I am not going to say anything about the fact that your initials are not there, but on your nameplate.
Say my own nameplate.
Mr. Tsatsawana, I don't usually do this, but I think from your debate with Justice Ngwetobe, something came to my attention that looking at that SCA order, because essentially the appeal lies against the order. I think that's the basis upon which we consider this appeal. Is that correct? Would you accept that proposition that an appeal does not lie against the reasons but
Yes.
the order? But
Yes.
looking at that order, as that debate showed, there is no order that we can reverse that deals with this question of power. So is it competent to just, is a competent appeal that can be entertained in that regard?
Yes, you remember the SCA.
We confine ourselves to the order.
Yes.
We say
yes.
that is what the appeal should be directed at, not at the reasons.
Yes.
And the order just declares the regulation to have had the retrospective effect and then deals with the consequences thereof and is silent on the power to condone.
Yes.
So what, if we are with you, what are we going to do? What must we do?
If you are with us.
On your interpretation.
Yes. If you are with us, then paragraph 1 of the orders of the SCA will have to be set aside. And that is the order dismissing ICASA's appeal to the SCA. That order that order is, we are appealing against that order, the dismissal of our appeal.
But the
That
High
order is
Court
appeal
didn't
against.
say you have the power, did you say that?
Yes, it said we did. That's why we went to the SCI. It said we had a statutory power to condone. And we appealed against that order, Order 1 and Order 2. And the Order 2 was the remittal order. Order 1 was to say, we have a statutory power to condone. I'll take you to it now. The appeal to the SCA lied against that order. And what we are asking you...
So the dismissal by the SA of the appeal means that the order that says that ICAS has the power stands. That's your...
Then that order
argument.
will be dismissed, yes.
Okay, thank you.
Yes, that will then be a dismissal of paragraph 1 of the order of the High Court, which you will find on page 011-602. And I think that's page 589 on just the paginated papers.
Sorry,
Thank you.
Mr. J, I had thought that we had covered this ground, but I think it's just been undone. The problem with that argument is that the SCA expressly says that the High Court's order is replaced.
Yes, but then...
So then it doesn't continue to apply. It's been replaced.
Yes, so that order is replaced. But what we are saying is that it was wrong for the SCA to dismiss our appeal. And that's
I understand that. That's why I thought your argument ultimately, which
Yes.
I was sort of superficially attracted to,
Yes.
was that there is an overarching interest of justice point.
Yes,
Because the narrow question about whether there is an order for us to reverse or not, the fact of the matter is that neither the High Court order exists nor the SCA order deals with the question of a virus to condone non-compliance. That's the current
Yes.
situation.
yes. You remember Justice Nuku then now took me to the order, and that debate was now in relation to the specific question that
Yes,
he
but
asked.
where that debate ended is by you submitting that the High Court order continues to operate in circumstances where the SCA expressly says it's replaced.
No, that order doesn't continue to operate. But what we are here for is the argument that the SCA was wrong to dismiss our appeal. And we have given the reasons why we say that.
Yes, but, okay, fine. I mean, that's okay, I understand that, but we still need to debate the question around why do we get involved in circumstances where there is no order to appeal against? And the way you got around that problem was to say, because the High Court order continues to operate. The problem is that it's irreconcilable with the express finding of the SCA doing away with it. So that's why I thought the argument ultimately is, look, you've got an overarching interest of justice power.
Yes.
Help us because we've got a crisis in our hands. And as a public body, we're asking you to help us.
Correct. Correct. That is the point. I think you and I concluded by referring you to paragraph 2.16 of our argument, and that's where the interest of justice argument is made. Yes.
Thank you, IDCJ. Mr. Tachwani, I've got one question for you, and it relates to the debate that you had previously with Justice Nkantobi. And the issue relates to the overarching interest of the public or the interest of justice that
Yes.
this court must give attention to this matter. It appears from the arguments and the answers that you've given so far, the key battleground is the interaction between the principle of legality, that is ICASA's lack of express power, and the doctrine of implied ancillary powers under Ampugani.
Yes.
And if I've heard your answers to the questions that was raised with you, it appears that you want this court to follow the Ampugani approach, the strict approach of necessity. Now, the question here is, with regard to that strict literal approach, does that not frustrate ICASA's primary constitutional mandate to regulate broadcasting in the public interest?
We submit not, because you can imagine in a situation like this, and I think one of the Spectrum cases did come before this court, where there are other players in the industry who do not have access to Spectrum. It is not in the public interest if there may be Spectrum available somewhere because someone is no longer going to use it, that ICASA must know that that Spectrum is no longer going to be used and I can allocate it to other players that may be available. That is in the public interest. So the strict reading and following of Amabungane, we submit, will not frustrate that. In fact, it will enable ICASA to regulate better in the public interest when there's clarity on it.
But ICASA's primary constitutional mandate is to ensure that the broadcasting is regulated within the public interest.
Correct.
Now, Open Haven, I mean, are they not broadcasting within the public interest?
No, well, to the extent that they have a license, yes, they're broadcasting in the public interest. But again, they must do that within the prescribed regulatory framework. And the prescribed regulatory framework says 6 months before expiry of your license, you must give notice that you still want the spectrum.
Thank you.
Thank you, Mr. Tatawane. We'll take, we're done now with the questions.
That's it, please.
Thank you. We'll take a tea adjournment until 12:05. Thank you.
Hello everyone. Please, let's get ready. And please, no food are allowed inside the court. Thank you.
Yes, Mr. Nguta.
Yes, thank you. Thank you, Justice Mkhanyi. We think this case is far more simple, but ICASA is trying to complicate it, and there's really no need for that. I've benefited from the debate between the court and Mr. Tsatsawane, and it has facilitated my task for today. We think you'll benefit from our submissions if we address the following topics. First, we want to deal with the retrospectivity issue. We say the amended regulations are retrospective in their effect. They say they are not. Secondly, we want to deal with their condonation powers under Section 19.2 of the ECA, although somewhat that debate may be irrelevant depending on your findings on the first issue, namely the retrospective effect of the amended regulations. Thirdly, we're going to deal with an omnibus topics in which we deal with all the other technical arguments they've raised, such as the order granted was not the order you sought before the High Court, and the SCA was therefore wrong to dismiss their appeal. And then we'll conclude by considering issues of course. Can I start then with the first topic? I think the exercise will be proper if we begin with the regulations themselves. I saw Justice Nuku tried to do that with Mr. Tsatsawane. I think that exercise is far more helpful. The regulations are on volume 3, page 237, on case lines. One of my learned friends may direct you. 011-240. We know previously Openhaven had its first license issued in 2012, and that was for a period of 5 years. That license is renewed in May 2017, still for a period of 5 years. When it is renewed in 2017, it specifies an expiry date. It says this license will expire in September 2022. But of course, that was in terms of the old regulations, the 5-year period. But something important happened before that expiry date in 2021, as we all know, 25 March. What happened? ICASA amends a raft of regulations. I think that's what happened. They amended various regulations, and one of those was the standard terms and conditions applicable to class licenses. And one of the things they did was to increase the period of validity for class licenses from 5 to 7 years. And we say that has retrospective effect, and they say it does not apply to those who had licenses at the time those regulations were amended. Of course, that contention is plainly untenable. Can we begin with those regulations? I think the relevant regulation, I just want to get there in a moment, is the amendment of regulation 4. You remember that regulation says on page 241 of volume 3, the following licenses are valid for 7 years from the effective date, and then it goes on to list various categories of licenses. We know my client falls under the first category, which is a community sound broadcasting service licensee. It says 7 years from the effective date. And then we flip back 2 pages to understand what do they mean by effective date. You find that at page 239 of volume 3, and they say, oh well, effective date means that the date specified in the license, which may be past, may be present, may be future, from the date of signature. And then what you do in order to determine this, whether or not this applies to my client, you go to their license. You go to their license, and my client's license will be on volume 1, page 29, case lines 011-42. When you get to that license, you will see it specifies an effective date. What is that effective date? I think September 2017. So how do you apply these regulations? From the date specified in my client in Openhaven's license, you reckon the period of 7 years. That is the only way you apply these regulations. Interpretation is now settled, but ICASA, I've listened carefully to their argument. They don't follow the approach established by this court and the Supreme Court of Appeal in a number of judgments, that triad of text, context, and purpose. They simply don't engage with the text at all. They say in their argument, as we understand them, well, it doesn't apply to you because there is a presumption against retrospective application of retrospective effect of legislation. Therefore, it only applies to those who will get their licenses after that date of the amendment. Of course, that contention is plainly untenable. This court has recognized, Justice Mhlanhla, in a number of judgments that we have a general presumption against the retrospective effect of legislation, but it is only a general presumption. It is rebuttable. It's a rebuttable presumption, and in appropriate circumstances, it will be rebutted by the language, the text of the regulation or the law itself, and in other circumstances, it will be rebutted by necessary implication. I think the SCA has said that in a number of judgments, and I think this court has also said it in S versus Mhlungu, a criminal case many years ago. So and of course, thirdly, the presumption will be rebutted where the amended regulation confers a benefit on those who are subject to it. Because remember, I think it was Justice Theron who debated the point with Mr. Tsatsawane. The presumption against retrospectivity is not there for its own sake. From many years ago, all of these judgments point the same thing. The whole idea behind the presumption is fairness. You don't want to interfere with people's rights that were acquired under previous legislation. But where there's no interference, there's only a benefit. Why not? It happens all the time when legislation, when laws are amended to confer benefits, especially in criminal cases. So clearly, this applies to all licenses, and you can determine that by the plain language of the regulation itself. How does it apply? They made the new period by specific reference to the effective date in circumstances where they knew that it would refer to a whole range of licensees who got their licenses many years ago, and they even in their regulations they define the effective date by maybe past, it may be present, it may be future. So they must have known. I mean, they regulate these licensees, and they definitely knew that it would apply to all of them. So at the SCA, ICASA was also invited to point to any interference against vested rights which the amended regulations would effect. They declined that invitation. They were not able to point to any. And the truth is, it is simply a fortuitous benefit on all the class licensees. it's just unfathomable why ICASA is fighting them tooth and nail for a benefit it objectively conferred on them. It intended to do that, and those are the consequences of those amended regulations. So we submit there clearly is there's no debate. I mean, ICASA has not attempted to address this point at all. I mean, mountains and mountains of arguments and long written submissions, but only 4 pages, about 4 or 5 pages are devoted to this point. So it tells you that there's no answer to that issue. So we say, just my topic, there's case law. Case law to the effect that where you apply amended laws prospectively, if the effect is to discriminate between 2 individuals, such legislation will necessarily be applied retrospectively. And one of those judgments we've cited in our heads of argument is an old judgment, Leck versus Estate Agents Affairs Board. I think we relied on page 611 of that judgment. The principle is simply that an inference of retrospectivity will be drawn where the prospective operation of regulations or new laws leads to absurdities. What are the absurdities here? We've tried to dramatize them in our heads of argument. We said, look at 2 licensees. You have myself, maybe Mr. Zungu. I got my license before the date of the amendment, maybe let's say 24 March 2021. What does that mean? My license, its validity is 5 years. But if Mr. Zungu gets his license a day later, 25 or 26, his license is valid for a period of 7 years. I mean, that's clearly absurd. By a difference of just a day between us acquiring or renewing our licenses, we get these stark results. And ICASA has not been able to explain these kind of absurdities. I mean, there's simply no logical reason why any lawgiver would enact such absurd results. So I mean, the argument is plainly inescapable. These regulations confer benefit. In this court recognized it in S versus Mhlungu that the presumption against retrospectivity is not meant to, to block benefits objectively conferred on subjects by new legislation. Where there's a benefit, regulations or amended laws will apply retrospectively. So it's our submission that there's clearly no argument on this point. So if we succeed on this, I think we should be home on this on these proceedings. We should succeed in these applications, in this application for leave to appeal, because it will mean that Open Haven did not have to submit that renewal notice, which has led to all of these proceedings, because its license was valid up until September 2024, not 2022. So that whole debate becomes academic and largely irrelevant. And then can I then move on to the second point? And I'll be brief on it. So ICASA, we know from these records that ICASA has always condoned licensees for late filing of their notices. And what is interesting is this: the section upon which they rely for their new argument, for a belated argument today, has never been amended. So before 2021, going back to 2005, when the ECA was first enacted, they've been exercising that discretion on good cause shown, and they even enacted that discretion and power into regulations, until they later deleted that provision when the amendments were made in 2021. So I mean, obviously there are no express powers in Section 19.2, but this court has recognized in a number of judgments, and we refer to a few in our heads of argument. In some cases, implied powers will be necessary in order to enable an organ of state like ICASA to exercise those powers expressly conferred upon them. And we've again tried to dramatize the point, and it's not only fictional in this case, because they've admitted during their argument that one of the issues we referred to in our heads of argument, namely the fire, did actually happen in 2014. There was a time, I think there was still somewhere around 17, an incident which a fire ripped through their buildings, and then licensees, when they went to submit their renewal applications, could not do it because not because they were late, but because of ICASA's problems. It's not hard to imagine other circumstances just like that. I mean, we just had COVID not long ago. I mean, 2 or 3 years ago, we just had COVID, in today's world, there are wars. I mean, there could be a war. Another country was just invaded, head of state seized and kidnapped not long ago by a superpower. So those instances are always objectively possible. And when ICASA approaches its powers in this rigid fashion, what are the consequences for that? I mean, they're going to be dramatic for innocent licensees who may not be to blame in those cases. I mean, just not long ago, ICASA's employees were on strike of some labor dispute, and it is not hard to imagine that a licensee like Open Heaven could be affected by events like that. You go there on your last day to submit your renewal notice, and employees are busy striking, and as a result, you can't do that. It looks like what ICASA is going to say is, well, it's your problem. Go on and let your license expire. And most importantly, we want to emphasize this, Justice Mhlanga. The period, the 6 months period, it's admitted on these papers that that is largely for ICASA's benefit, and we agree on two things with ICASA. First, we say that purpose allows them, that 6 months period allows them to avoid a last-minute rush. You know, licensees all at the door trying to submit their renewal notices. So it gives them enough time to process those renewal notices. Secondly, it gives them time to manage the spectrum. You know, with these radio stations, CASA has a spectrum plan where it allocates spectrum bands to different radio stations. So it also allows them enough time to deal with that spectrum allocation. So, I mean, given this, the 14 months out of that period, but the license itself has not yet expired. It would only expire in about 5 or 6 months' time. ICASA says, well, there's nothing I can do about it. Could those objectives not be those objectives for which that period, 6 months period, serves, not be fulfilled within that period? Of course, it would be fulfilled. So ICASA is clearly unreasonable. We've looked at some of the cases decided by this court on implied powers. Like if I still recall, Masetla, for an example, I think the president had an express power to appoint the head of intelligence, but there was no express provision on whether or not he had the power to fire the president. And this court, quite correctly in our view, said that that power to dismiss is a necessary corollary of the power to appoint. It's very evident in this case that if ICASA, approaches its powers the way it does, we're going to be in a cul-de-sac very soon. The licensees are not to blame, yet they are losing their licenses through no fault of their own. We respectfully submit that should not be accepted. We know from this record that while the appeal at the SCA was pending, Openhaven submitted a conditional renewal notice based on the 7 months period, and ICASA's reaction was an iron hand of bureaucracy. Just want to get this. An iron hand of bureaucracy. A reasonable proposal is made to them. Say, well, the appeal's pending. We think we may win on this retrospectivity point. And when we win, we don't want to be confronted with a situation where we've won the main argument, but we no longer have a license because we failed to renew it timeously, 6 months before the period expires. We therefore submit this application conditionally, depending on the outcome of those proceedings. Alternatively, if you don't want to accept it, please give us an undertaking that you will not regard our license as having expired for our failure to submit a renewal license. Their response is really dramatic. Another instance of bureaucratic oppression. They said, no, we're not going to do that. And in their tough language, volume 6, page 49, those lawyers writing on behalf of ICASA, the above, I'll read from the second sentence. Any unlawful conduct by your client will be met with the appropriate law enforcement measures, and your client is called upon to resist the temptation to broadcast without a license as suggested in your letter. That's really dramatic, especially for ICASA. Remember, ICASA is not only an organ of state; it is a Chapter 9 institution, and one of its purposes is to regulate broadcasting in the public interest. And some of those objectives are now filtered through to the ECA. It must encourage and support community broadcasting, support SMEs, ensure a diversity of views and opinions in our public broadcasting. So it looks like their approach effectively is to, as a consequence of this interpretation, will lead to a new aristocracy in broadcasting, in which poor communities are excluded from broadcasting. They can't speak their own languages. They can't practice their culture, listen to news in their own home languages. We think that is wrong, and this court should not tolerate that. I then want to move on and deal with their technical arguments. ICASA says, well, at the order granted by the High Court and maybe endorsed not endorsed, granted by the High Court was not the order you sought when we went there, and therefore we were not called upon to debate the issue upon which that order is founded. But of course, there's really no substance in that argument. The whole debate between the parties throughout, from the High Court all the way to the Supreme Court of Appeal, was whether or not they have these powers. We argued throughout that you do have these powers. They are implied and they are necessary in order for you to exercise your express powers. So the High Court, even if I mean, its order is not before you. It is that of the SCA that's before you. Even if it could be criticized on some basis, it did hear them on what on the relief it ultimately granted. So there's really no substance in that argument. Mr. Tsatsawane, in his argument, has attempted. I'm sorry, I just want to get a quick reference. He has attempted to distinguish some of the judgments upon which we rely, such as all pay for the principles we submit. And he says, as I understand him in his argument, well, all pay dealt with a different matter altogether. It dealt with a tender, and therefore that should not be applicable here. But I mean, this has been criticized in a lot of judgments. I just want to quote one quick reference in which this kind of approach was criticized. We know decided cases are useful for the general principles of law they set down. It is not a contest of facts. Many years ago, the then appellate division dealt with exactly the same argument by Mr. Tsatsawane, and it's a judgment of Justice St. Levers. You don't need to go to that judgment. He said, no inquiry is more idle than one which is devoted to seeing how nearly the facts of two cases come together. The use of cases is for the propositions of law they contain. It is no use to compare the special facts of one case with the special facts of another for the purpose of endeavoring to ascertain the conclusion you want to come to. We think Mr. Tsatsawane and CASA deserve that criticism. May I then, I just want to, I want to conclude. On leave to appeal, we've set out our arguments, we've set out our submissions in our heads of argument. And I've listened to the debate between Mr. Tsatsawane and the court. We embrace some of the submissions. We embrace some of the comments from the justices. We think leave to appeal should be refused, largely because their main issue will become irrelevant if you are with us on the 7-year period, and there's a renewal application before them which they unlawfully rejected. If you're inclined to grant them leave, then the appeal itself must be dismissed. In each case, we ask for costs of 3 junior counsel. We don't think that's extravagant. We think it's a fair and reasonable precaution, given that ICASA has always retained the services of senior counsel assisted by a very able junior. If you're not with us, in the unlikely event that you're not with us, we say we enjoy Bywatch. Justice Mtantla, thank you so much. Those are your submissions.
Yes, thank you, ATCJ. So I didn't get your surname.
Sorry, Nguta.
Mr. Nguta, all right, thank you, Mr. Nguta. Yes. I just needed to get some clarification about why you submit that ICASA's rights are not infringed by the first interpretation that they propose. My understanding of ICASA's argument is that they would like to retain for themselves the right to assess whether or not your client has complied with its license conditions. And an automatic extension to 7 years deprives them of that right. And so it's not as if this is a benefit conferring provision without an invasion of existing rights. How should we address that concern?
No, well, just like I think they are incorrect. There's no right there. It is a power, not a right. a right is obviously is always in the nature of some entitlement, like you get a license, you can do that, you can run a business, run a fiber company or that sort of thing. But what they are contending...
No, I understand,
yes,
but
yes.
are they actually prohibited from investigating your client's compliance by the mere extension of 5 years?
No, they're not. They're not. Because remember, all of these broadcasters are still subject to their regulation. They're not prevented from investigating them. And if they find any issues of non-compliance, enforce the regulations or even cancel or suspend the
And where would they get that power from?
I think that power, I think it should be within the ECA, because I can look for those provisions. Remember these licenses, once granted.
No, I understand. There's
Yes.
quite a lot of externalities to be explained.
Yes.
If you could just assist me with identifying the answer that, look, ICASA is wrong.
Yes.
They are not prohibited. This is their power to investigate if we have not complied.
I'm sorry. Can I get the question again?
Just assist me with a
Yes.
direct answer by identifying where the power is to answer ICASA's concern that an automatic extension deprives them. The right, you say it's not the right, it's the power, but let's forget about the technical
Yes.
label.
Yes.
But where would the power be to investigate your client's compliance in order to enable ICASA to terminate the license? Because that's the argument they make, that, well, you've now got an extra 2 years. We can't do anything about you for the next 2 years.
But clearly that's incorrect.
Yes, where just give me
yes.
the section that would be applicable.
I don't think there would be a direct section, but we've attached in our heads of arguments the regulations dealing with these class broadcasters, and they deal with a range of things. For example, you must always have a board. Your programming must be compliant with your license conditions. You must submit compliance reports as and when required under those regulations. So even if you get that extension, that 2-year extension, you still must comply with those regulations and maybe other regulations that may be applicable to you.
No, I understand that. I just want to get the actual answer to say,
Yeah.
look, they are wrong. This is their power. They can discipline us. They can take our license.
Yes.
Now, the reason is because I couldn't find that in the Electronic Communications Act,
Yes.
because the power there to terminate seems to exist only in respect of individual licenses.
Yeah.
And I couldn't find a comparable provision in respect of class licenses. Could you find it? Or can you just?
No.
All right. Then, that then meant that I had to look elsewhere.
Yes.
And in the ICASA Act, I just want your submissions whether this would be applicable.
Yes.
Under Section 17, capital A,
Yes.
which deals with the Complaints Committee,
Right.
which seems to be overarching and deals with every complaint regardless of the
Yes.
classification.
Yes.
Would that be applicable?
Yeah, I think ICASA does that every day. I mean, whenever there are issues of non-compliance by these radio stations, they refer them to the CCC for prosecution. And the CCC, after hearing argument and finding a substantial non-compliance, may impose fines and maybe in some cases propose the cancellation of a license itself.
Yes, but would that be the section that gives them the power to discipline your client if your client doesn't comply?
Yes, I think so, yes.
Yes, so would that be then the reason why their main submission is wrong, that the extension deprives them the power to discipline your client?
I mean, that must be plainly wrong. I mean, there's the relationship between regulators and licensees is always through licensing. I mean, they still remain under ICASA's regulatory powers, and where there's non-compliance, they may be prosecuted and face the risk of losing a license or exorbitant fines.
Thank you, 8th Street.
Yes.
Mr. Nguta,
Yes.
let's go to the issue of the condonation aspect where you
Yes.
say ICASA has implied powers.
Yes.
The section 19.2, it says that licensees seeking to renew their class licenses must in writing and not less than 6 months prior to expiration notify the authority.
Yes.
How is this done, this notification? Is it the actual application for renewal, or is it just a mere letter to say we are going to apply in due course, or what? How is it done?
So you see, I mean, that's an interesting one because the legislation says it's a notice, it's a mere notice, it's not an application. But what ICASA did, exercising their powers under the ECA and the ICASA Act, was to draft a lot of regulations which has a detailed format. It's a very long form. They must complete and attach a lot of documents, almost like an application, if you will. All their details, governance structures, their founding documents, and maybe details about auditors and the like. And then they submit that renewal notice. But I mean, I think this yes.
Excuse me. Should we read that with sub 3,
Yes.
which says the renewal notice contemplated under sub 2 must be submitted to the authority
Yes.
in the manner prescribed as contemplated in section 5.7. 5.7, you know, is the regulations.
Yes.
And they also have rules on what should be
Yes. Yes. I think that is correct. They've prescribed a format on which these renewal notices or applications are to be submitted, and it's. I mean, in our submission, we think those detailed forms go way beyond what is contemplated by this section, which is basically a notice to say I still intend to continue broadcasting, but they've exercised their powers, and that has not been up for debate as yet.
And you say that in the forms that are set out in the regulations, there's a provision where it says if there's a delay, you must explain why there's a delay.
You see, what happened is this, Justice Mhlanhla. Before 2021, all of those forms had that provision. Is this application late, or is this renewal notice late? If yes, give reasons. Then when they somersaulted and changed their position in 2021, they just went to those forms, deleted that portion about condonation.
Okay.
But the point is, the legislation upon which they base the section upon which they base all their arguments had never been amended, had remained the same, which is 19.2 of the ECA.
Okay. Now, their concern is that there's a provision that is 11.9
Yes.
relating to the individual licenses, which is expressed very clear,
Right.
which gives them the power
Yes.
to consider a late application,
Yes.
and if good cause is shown, condone the late application.
Right.
They are saying we don't have that in respect of the class licenses.
Yes.
And without that clear provision,
Yes.
they don't have the power.
Oh, of course. I think, Justice Mhlanhla, our submission is this. They rely on that exclusio maxim. You know, if expressly stated here and not there, therefore it must be excluded. But this court has said in one of its judgments, this is only a maxim. We must be careful about it. We've referred to it in our heads of argument. I think the language was a court must approach it not with caution, but great caution. You must approach it with great caution. It might mean nothing. Maybe, I mean, because there's clearly no purpose for that kind of discrimination between class and individual licenses. There's simply, it's difficult to fathom why there will be any rational basis to discriminate between them. So we say they are correct on that, facially they are correct on that argument, but that is only an aid to interpretation. This court knows the correct approach. Interpretation is now through the prism of the Bill of Rights. You consider all of the text, context, and the purpose of those provisions. And we say, I mean, given our Bill of Rights, it would be such an extraordinary thing to have these community broadcasters lose their licenses, while individual licensees seem to be privileged, so to speak.
Of course, one thing that is a bit odd is that in respect of the class licenses,
Yes.
the license hasn't actually expired.
Yes.
It's basically the notification that must be given to ICASA
Yes.
6 months before the expiry
Yes.
of the license.
Yes.
What is the position in respect of the individual licenses?
Um,
When do they
yes.
apply for renewal? Is it before or when one talks about condonation, it's
Yes.
when that application for renewal is done after the expiry?
Yes. Well, I looked at section 11. It doesn't seem to prescribe it. It doesn't seem to prescribe a period at all, unless
It refers to subsection 2. I
Yes.
suspect those will be the regulations.
Yes. Yeah. So there's no. It looks like there's no prescribed period there. I haven't looked at those regulations recently, but as I understand it, it doesn't seem that there's any prescribed period. You can just go in and submit it even the day before. I'm subject to correction on this.
They say also you haven't really challenged the provision. If you're saying there's a differentiation, why do you deal with the one group as differently from other? You
Yes.
haven't challenged the provision.
Yes.
What do you say to that?
Well, we didn't need to, although maybe in retrospect we could have added that there. But I know this court has said, I mean, if it is possible to get the relief you seek without challenging the legislation itself, that should be the proper course. In the circumstances of this case, we think it is possible to read 19.2 in the manner we suggest, and there's no need to challenge the arbitrary discrimination between these two provisions, or have 19.2 struck down for its discriminatory impact on class broadcasters.
And the manner you suggest is that we must say they have implied powers because of what?
I'm sorry, can you repeat that?
You're saying we must say they have implied powers.
Yes.
On what basis?
Well, because in the examples we've tried to dramatize during our argument and in our written submission, there are glaring instances where they will not be able to use their express powers, which is to decide on a renewal in certain circumstances. For example, the fire incident, you're at the gate, there's a fire, you can't submit your application, you must go back home. Must you lose your license because of ICASA's problems? It just seems, it leaves a bad taste in the mouth.
Thank you.
Thank you, Justice Mkandla. Mr. Nguta,
Yes.
it seems to me that the case law on material compliance and implied powers of condonation could be said to be disjointed and perhaps even on occasion contradictory.
Oh, yeah.
Even if the question of retrospectivity is decided in the respondent's favor,
Yes.
would it not be in the interest of justice for this court to clarify the law on material compliance and implied powers?
I think there's we have enough in our case law. I don't know what more could we say. I mean, Court cases are like that. They seem to keep evolving. You're going to get this opinion now, and you have a different panel. You might get slightly different opinions on the topic. But I don't think. I mean, what ICASA effectively seeks on that point is advisory. I wouldn't think it's in the interest of justice. I mean, there's sufficient case law on that, both from this court and
The Supreme Court of Appeal didn't consider its own judgments in Morocco
right.
and Pepper Bay.
Yes.
Did it err in failing to do so? What must this court do about that?
We submit the point is legally irrelevant. Even though the Supreme Court of Appeal ignored its previous judgment in DS Morocco municipality, but it directly relied on the authorities of this court, namely all pay, that the compliance with legal requirements must be linked to the purpose. So. It's up for debate, because the approach followed in Millennium Waste seems to be consistent with this court's approach in Old Pay, that compliance is not just for its own sake. You link it to the purpose of the provision.
Now, if we put aside the authority in Pepper Bay and in JS Morocco,
Yes.
in Gous, the Supreme Court of Appeal said that there is a general rule,
Yes.
or the general rule is that statutory bodies only have powers that are expressly conferred by law. And this court has held that ancillary powers will only be implied where they are reasonably necessary for the exercise of a primary power.
Yes.
Now, this is my question to you, Mr. Nguta.
Yes.
Which of ICASA's primary powers will it be unable to exercise without the ancillary power to condone non-compliance?
Yes. So let me just begin with Amapungane. As I recall, the principle there was that ancillary powers will be necessary where the primary powers, whether express or implied, won't be, you won't be able to exercise them. So the primary power ICASA has in terms of 19.2 is to decide on those renewal notices. Once received, decide on a renewal notice or renewal application. So on the instances we've dramatized before this court, we're gonna run into a cul-de-sac very soon. There's a strike, there's a fire in their building. They're not going to be able to exercise those powers, and the licensee is not going to be at fault. What are we going to do there? So Mr. Tsatsawane, as I listened to him, said, well, we might in that case need to go to the High Court in order to get some relief, in terms of which they ask them to allow us to exercise some powers. But when you come to the court, you're going to say, where are the powers on their own argument? You're going to say, as a judge, I must give you powers to do this renewal, but where am I gonna get them? So I think that's so we need to be cautious cautious on, against that argument. So in simple words, Justice Theron, their primary power is to decide on those renewal applications, and there will be clearly on the submissions we've made instances where they will not be able to exercise those powers.
Can you give an example? You say there will be instances. Can you give an example of such an instance?
It happened here. In 2014, ICASA had there was a fire in their building, and when certain licensees wanted to go and submit their renewal notices, they couldn't do that because there are work people and emergency staff and things like that. And yes.
My question, Mr. Nguta, is
yes.
Which primary powers will ICASA be unable to exercise if the ancillary power to condone is not granted?
Yes, the primary power is to decide a renewal application, Justice Theron, because only they have the power to decide that those renewal notices under section 19.2. That is their primary power. But I mean, when you read through that section, you won't get it in such express language. ICASA has the power to decide on this, but it's clearly implicit there, and I think it's consistent with what this court said in Amapungane, that those primary powers may be expressed or implied, but in certain instances they will need implied ancillary powers in order for an organ of state to be able to exercise them.
I have some difficulty with the statement that express powers can be implied.
Okay. Well, but so it's your judgment. I'm not sure if you're part of the panel in Amapungane. So we're giving you back your words in Amapungane. So that's.
I'm on the same page, Mr. Nguto,
I'm
but
sorry.
I will leave it there.
I apologize.
Mr. Nguto, I just want to ask you a question about the order of the High Court
Yes.
and the order of the SCA.
Yes.
Mr. Tsetswai did debate this with the court, but I would just like to have some clarification.
Yes.
Now, the High Court order declared that ICASA has the power to condone. That was the order that it gave. It said nothing about retrospectivity.
Yes.
Now, the SCA refers to that order, and then it says in paragraph 13, it is against the above order that ICASA is appealing. Now, it dismisses the appeal. So does that mean that the High Court order regarding the power to condone still stands? That's my first question.
Yes.
Then it says there are two issues before the court. The one is a condonation issue, which the High Court made a declaration, and the appeal against that order seems to have been dismissed.
Yes.
Then it goes over to the cross appeal, and it upholds the cross appeal, that we know. And then it goes on to make an order purportedly setting aside the High Court order, which it has just dismissed the appeal against,
Yes.
and substituting it with an order that actually deals with a cross appeal. So my point is this: how should we read the order? Does, as Mr. Tsetswai argued, we are appealing against the order of the High Court, which was upheld. So I'm just a bit curious as to how we should interpret the two orders. How should we read them?
Justice Bazon, I think there should be no difficulty with this. And I embrace what Justice Nkaitobi put to Mr. Tsatsawane earlier. We know the order on appeal before you is that of the SCA and not of the High Court. When the SCA considered the appeal and cross appeal, it dismissed the appeal, upheld the cross appeal, and then replaced the entirety of the High Court order with its own order. And of course, as you know, that normally comes from the notice of appeal filed by notice of appeal or notice of cross appeal filed by other of the parties, in which they ask for we ask that you dismiss this, uphold this, and replace that whole order with what we suggest. And in our submission, what is before you is that order of the SCA and not of the High Court. And there are no consequences in which.
Yes, but the SCA order does say.
Yes.
The appeal is dismissed.
Dismissed, yes.
That's all I wanted to clarify.
Well, it does, but I think it would be too much to infer from that it somehow revives the order of the High Court as I understood Mr. Tsatsawane. I think that order is not before this court, and what is before you is the SCA order.
Back to me, Mr. Nguto. I want to deal with the argument as to whether, and this is the applicant's argument,
Yes.
there has been a conflation of the test for an implied power to condone and the test for material compliance with legislation. And I want you to consider, what are we dealing with in this case? Now, the test in SA Eagle deals with the waiver of a requirement.
Yes.
And it holds that a benefit enacted for a particular body may be waived, provided no public interest is affected.
Yes.
So that deals with the power to condone. The test for material compliance asks whether the purpose for which the requirement has been enacted has been fulfilled.
Yes.
So what are we dealing with and what's the test?
Just as the I think we're dealing with both of those. We've raised them in our submissions. And first, we say on this condemnation point, there are implied powers, and we rely on these court's judgments, including Amapungane. And then we say, if you're not with us on that, then ICASA should have condoned that late filing because it was in the public interest to do so. And thirdly, and maybe somewhat clumsily, I don't think we've raised it squarely, is that there was substantial compliance given the purpose of that section.
Now, doesn't your answer in fact demonstrate
Yeah.
why this court should deal with the matter? Because let me rephrase.
Yes.
I want you to consider what the effect of this judgment on the implied powers of all administrators across the country would be
Yes.
if this court finds that the SCA judgment stands. Would it not create uncertainty as to which requirements an administrator can waive or condone and when it is entitled to do so?
I think there's enough case law in our jurisprudence, and as I understand the approach, it is all flexibility. I mean, there's no tick box exercise in which administrators advise to ignore this, take into account that and that sort of thing. I think it's that flexibility, and you know, in most cases, there's the whole notion of a good cause shown. It happens in a lot of other areas of law, but we think it should all be around flexibility and context, taking into account the effects of each individual case.
My last question, Mr. Muta.
Ah, thank you.
How does the present case differ from Liberal Party, where the applicants were just 21 minutes late?
Yes.
How does it differ from Pepper Bay, where the applicants were a day late?
Yes.
And in those cases, the court found there was no power to condone.
Yes.
And the court didn't venture into the material compliance analysis.
Yes.
So which cases are right, which cases are wrong? What should we do?
I think the material difference, Justice Theron, first, on the very same paragraph relied upon by Mr. Tsatsawan, seems to undermine his very argument. They say there, I think effectively, the commission, electoral commission, has no power to condone the late filing in this case. And then this court continues in the next sentence and says, especially in circumstances where there is no objective evidence on the record that they have done a similar thing in the past. But it's wholly different here. The case is altogether different. There's a mountain of evidence. I'm being dramatic. It's not a mountain of evidence. There are instances in which ICASA has done exactly the same thing, exercised the very same powers. And we pointed to those instances in our heads of argument, that general notice of 2014, and they also had those those 2008 regulations in which they made that provision for condonation in instances of late filing.
Thank you.
Thank you.
Mr.
Appreciate it.
Sorry, Mr. Guta, to
Yes.
take you back.
Yes,
But on the debate you've just had with Justice Teron,
yes.
I think the question is by how much do you want to win? By 2-0 or by 1-0? You see, because how does this affect your client, whether or not ICASA has the power to condone? Because it seems not to affect your client at all.
No, I embrace your.
So then, why then are you resisting it? Your client is only affected by the retrospectivity issue.
Yes.
So if we decide that in your client's favor, so what's your bone then?
Yeah, I mean, I just want to cover all bases.
Yes, no, but what's the relevance to your client? I think,
Yes.
I would imagine that the short answer is that this is irrelevant to my client.
No, it is,
If my
it is.
client is right on the retrospectivity issue,
Yes.
the court must do whatever it wants to do in relation to the condonation issue.
I
It's
accept
only
that.
ICASA that's interested in that fight.
I accept
Your
that.
client is on time in relation to its extension after the 2 years.
Correct.
Thank you.
I accept that. Thank you, Justice Mhlahla.
Reply, Mr. Tsatsawani?
May it please the court, Justice Mhlante. There is just one point that I must address in reply, and it is this issue that relates to the possible mootness of the appeal and why this court should still entertain an appeal. I just want to refer the court to this court's judgment in Independent Electoral Commission versus Langeberg Municipality, where this court emphasized that the fact that an issue may have become moot is not on its own determinative of whether or not this court should entertain appeal. And this court said the issue remains whether the order will have practical effect on the parties or others, meaning other people who are not necessarily in this case. And we submit that this is exactly such a case as we set out in our heads of argument, that there are other pending applications that are waiting the determination of this case. And in addition, if the judgment of the SEA is to remain standing as it is now, it is indeed going to create confusion as to the powers of organs of the state who have the same type of provisions. And we'll submit on that basis that a case for leave to appeal has been made, and we ask that the appeal be upheld as we set out in our heads of argument. That's the only issue in reply. Thank you.
Any questions? Thank you. Thank you very much, Mr. Tsawani.
As it please the court.
Take time and consider the matter. Judgment is reserved. Court adjourns.